One of the things that I said I would talk about this week in one of my videos is a defense from deportation for people who've been here for a while. If you are targeted by immigration and customs enforcement, or if you receive a notice to appear in immigration court. So what we know right now is that ICE is tending to do targeted enforcement operations. So they have a specific person who they want to target, and they go to their home or their place of business and they try to detain them or give them a notice to appear in immigration court for them to voluntarily appear in court. But when they do these targeted enforcement operations, if they encounter other individuals who are in the US without authorization, without status, they oftentimes are forced to take additional action and place that other person into removal proceedings as well. So let's say that other person who's just minding their own business and placed into removal proceedings is you. And let's say you've been in the US for more than 10 years continuously, and then you come to me. What would we talk about? That's what today's video is about, a defense from deportation that some people might not know about. This defense is called cancellation of removal, and there are three main requirements. Number one, you must have been physically present in the United States for at least 10 years before issuance of the notice to appear. Number two, you must have been a person of good character during those 10 years. So good character generally means no criminal history and paying taxes. If you haven't been paying taxes, the good news is many immigration judges will just let you retroactively pay 10 years of taxes to fix that good moral character right before we get to your final trial date so that you qualify for this defense. And number three, and this is the most important part of this whole thing, is you have a US citizen or permanent resident, child, spouse, or parent. So you need a family member who is a qualifying relative. They must be either a US citizen or a permanent resident, child, spouse, or parent. And you must demonstrate that this person will suffer extreme and unusual hardships if you are removed from the United States. And let's talk about what that means. Extreme hardship means that your qualifying family member will suffer more hardship than a normal person would experience under those circumstances. Let me give you an example. Let's say you have a child who has some sort of disability, or a spouse who has some sort of disability or health condition, and you can demonstrate that they depend on you more than a normal child or spouse would. I mean, if your child is disabled and that disability is somewhat severe, and you are one of the parents who takes care of that child, or the only parent who takes care of that child, I think that at least in New York, most immigration judges would determine that that qualifies as extreme hardship, but it's gonna depend on the exact factual circumstances of your case. It's gonna depend on how much that child depends on you and the level of severity of the disability. I have a situation where a spouse suffers from seizures, and they are entirely dependent on their immigrant spouse for a variety of daily activities of living. And because of that, the immigration judge, if this person was placed into deportation proceedings, would likely find that their US citizen spouse would suffer extreme and unusual hardships if the immigrant spouse is deported. So what happens if you end up qualifying for cancellation of removal? Well, first of all, it's a defense from deportation. You can't just affirmatively apply for it, although some people try. The way some people try to affirmatively apply for it is by filing a weak asylum application, which will eventually get denied and place them into deportation proceedings. And then once they're in deportation proceedings, they basically tell the judge, I no longer wish to pursue asylum. I wish to pursue a different defense from deportation called cancellation of removal, and then they apply for that. This does backfire sometimes. For example, if you start this process when your disabled child is 10 years old, and by the time it's time for the judge to hear your final case, your child is now 21 years old, you might be out of luck. You no longer have a qualifying relative. You no longer have that child who's under 21 years of age, who's a US citizen and will suffer from extreme and unusual hardship. And depending on what the government policies are, that strong case might end up turning into a deportation order. So as a general matter, we never want to place someone in deportation proceedings just to pursue this, absent extraordinary circumstances where they actually have a viable asylum case as well. But what happens if you do qualify and your case gets approved? Well, instead of getting a removal order, you'll actually end up being granted permanent residence. And this is particularly fascinating for people who are subject to the permanent bar, because even if you're subject to a permanent bar, which prevents you from becoming a permanent resident through other family petitions and family-based immigration pathways, cancellation of removal can still be a pathway to permanent residence even when you have the permanent bar, as long as you meet the other requirements. So generally speaking, this is what I would tell someone who's sitting in my office and who clearly qualifies for cancellation of removal. I would tell them, look, you haven't been placed into removal proceedings. There's a low chance that immigration is going to actively seek you out to give you a notice to appear. But if they do, it's going to be important for you to invoke your right to see an immigration judge. You've been physically present in the US for more than 2 years. And if you're physically present in the US for more than 2 years and you can prove that you've been here for more than 2 years continuously, you generally have a right to see an immigration judge. So if immigration contacts you, you should generally remain silent, refuse to sign anything, ask for an attorney, and invoke your right to see an immigration judge once you have the attorney present. Once we see an immigration judge, we can then apply for cancellation of removal. Now, recall that I said this person must have evidence that they've been physically present in the US for more than 2 years continuously. I do recommend at this point that you carry that evidence with you, whether it's bank statements, car insurance documents you've renewed, medical appointment history, meetings with your children's PTA, anything that proves you've been physically present in the US continuously for 2 years will give you a right to see an immigration judge. So it's important for you to have that on you. It'll be your burden to demonstrate that you've been continuously present in the US for 2 years if you want to see an immigration judge. And then at that point, we could always apply for cancellation of removal. All right, guys, so that brings us to the end of today's video. If you found this topic interesting, be sure to subscribe to my channel. I'm going to be putting out a lot of family-based immigration and naturalization topics over the next year. And anytime there's a change to immigration policy, Trump does something that it affects immigrants, I'm going to make a video on the topic to keep you guys up to date. If you need assistance with your immigration matter, or if you think you qualify for cancellation of removal, or you want to learn more about what the procedure is before you marry your immigrant spouse as a US citizen, you want to petition for them, you want to understand what that process looks like, or you might even want to hire an attorney to do it for you or to give you advice along the way, I'm your guy. Schedule a consultation, and I'll see you guys next time for another video.